Hello everyone, welcome to Law Excellence IAS Kalam program Season 2 Episode 43. This is a GS Mains answer writing initiative and we will be continuing this season for about 50 episodes. I have an important announcement to make. Law Excellence IAS is coming up with a prelims cum mains batch for 2021. These will be in the form of online live classes on Zoom from 7th May, that is from today. Once the lockdown is lifted and the institution starts opening up, these students can avail offline classes also at Hyderabad at Bengaluru. For further details, contact the number given in the description. Let us now look at today's question. The question says, the idea of virtual courts can provide the judiciary with an opportunity to ensure speedy disposal of cases and optimum utilization of resources. Discuss. This question is from General Studies paper 2 from the topic of judiciary and from the subtopic of virtual courts. This question is for 10 marks and we have to write the answer in 150 words. If we look at the context in which this question has been asked, following the lockdown, Honorable Supreme Court has ordered all the courts to undertake the proceedings using video conferencing. The COVID-19 pandemic has called for social as well as physical distancing of people. As a result, there has been closure of all organizations where mass gatherings were taking place. Most works we are doing online, including purchasing of the groceries. Wherever possible, we are working from home. So it is now time for embracing the virtual judiciary or the e-courts so that lot of pending cases can be solved with the existing infrastructure itself. E-courts or virtual proceedings has got many advantages. It decreases the costs, it decreases the judicial costs as well as it saves court time as well as the time of lawyers and litigants. The filing of cases, paying of fees, etc., everything can be done online. However, there are certain concerns as well. The issue of cyber security threats, especially in the era of dark net, is a major risk. Along with that, there is no continuous internet and electricity supply everywhere in the country. Okay, in view of this context, this question has been asked about how the resources can be optimally utilized and how pending cases can be disposed faster by making use of virtual courts. Okay, let us now look at some of the value addition points that can be written in this answer. You can write about the articles from the Directive Principles of State Policy which call for equal justice and free legal aid. That is Article 39A. How speedy disposal of cases means equal justice? Because justice delayed is justice denied. So, in order to ensure equal justice, we have to speedily dispose the cases and ensure that justice is done. So, Article 39A of the Indian Constitution, which comes under DPSP, asks the state to provide for equal justice and free legal aid. This can be written as a good value addition to our answer. Apart from this, there are many facts with relation to the pending cases in the judiciary. Okay, the judges to population ratio is just 19 per million, whereas the Law Commission says the requirement is 50 per million population. So the low number of judges to population could be written as a value addition. Also, there are more than 5,000 vacancies in the lower judiciary. You can also write facts about number of cases pending in the courts, inefficient resource utilization, either due to vacations or because of reduced working hours of the courts or because of poor functioning of the tribunals. And then, apart from these facts, you can write the government's project for e-courts, that is mission mode project for e-courts and its current status as a value addition point. And you can write Commission's recommendations like Niti Aayog's recommendation for embracing technology, or the Economic Survey of 2018-19 has called for usage of e-courts for faster disposal of cases. You can also talk about National Judicial Data Grid, which is a part of the mission mode project of the e-courts. So these are some of the value addition points you can write in this answer. Coming to what is to be avoided in this answer, I think This question is specifically asking about the virtual courts or virtual judiciary. So other steps which are taken or suggested for judicial pendency, like the All India Judicial Service as suggested by Niti Aayog, or the Lok Adalats which have been functioning, or the tribunals which have been functioning, it's better not to mention about them, or even if you mention, write them in the introduction or conclusion as other mechanisms for speedy disposal of cases, but don't try to detail about these issues. Coming to how to write the answer in the introduction, body and conclusion format, I think this answer can be introduced in two ways, either by defining what virtual judiciary or virtual courts are, or by giving the problem statement, that is regarding the pendency of cases or regarding the inefficient utilization of resources. If you observe the question carefully, it is telling that virtual courts can ensure speedy disposal of cases and optimum utilization of resources. So you can tell about the problem statement in the introduction. Coming to the body part, I think body can be written in three parts. In the first part, you can expand the problem statement, that is telling about the pendency, inefficient utilization of resources, giving facts and figures could be done in the first part. Coming to the second part, you can write about the need for virtual courts as well as the advantages of the virtual courts. Coming to the third part, you can also mention about some of the problems that are existent to prevent virtual courts from coming up. There are certain challenges which prevent virtual courts from coming up. What are these challenges? You can discuss. For example, the cybersecurity threat, which I already discussed. Coming to the conclusion, I think the best way to conclude would be to summarize the problem, and the need for virtual judiciary can be written as a conclusion. Let us now look at a sample answer. So this person writes, virtual courts refer to the usage of information and communication technology platform for conducting the proceedings of the cases without physical presence of the litigants and the advocates in the courts. So here he is trying to define virtual courts in the introduction. He is then going to write the advantages of virtual courts. He is writing, avoids the need for physical movement of people. Yes. He also writes resolution of pending cases because of faster proceedings. So virtual courts cause for faster proceedings. The lawyer's waiting time will be reduced. Also, the long travels by the lawyers as well as litigants will be decreased. So the cases will be proceeding faster because the presenting time given to the lawyers will also decrease. As of 2018, around 3 crore pending cases in various courts of India. So here he is trying to write the value addition point which I told, that is a fact relating to the pendency of cases. He is writing here, and then he is writing access to justice at affordable cost. Online filing of cases, payment of fees, checking of status, etc. can all be done online. He then writes there is privacy to the litigants. Yes, there is a privacy to the litigants because unlike in the normal courts where publicly proceedings happen, there is privacy to the litigants in the virtual courts. Also, online storing of the records saves space, paper and time. Also, faster retrieval of older records happens because of this. If somebody wants to retrieve an older case judgment, it can be done with the click of a mouse. Okay, so faster retrieval of older cases because of online storing of the records. Also, there is more transparency in proceedings. Anything that is virtual or taking place online will have to be recorded in a systematic manner. It cannot be tampered easily unless by a cybersecurity threat. So there is more transparency in the proceedings. So he has written the advantages of virtual courts, especially with respect to pendency of the cases as well as better utilization of the resources by online storage of records. Also, decreasing the need for movement of people and faster proceedings will save lot of time for the people. Moving further, he is writing challenges for creation of virtual courts. high upfront cost for setting up the ICT infrastructure in all courts. Yes, the cost is going to be too high for setting up this ICT infrastructure in all the courts in India. Then the lack of continuous electricity and internet supply, this point we have already discussed. Complicated process of e-filing. Yes, filing of cases online is not very easy, it is quite cumbersome, so that is also one of the challenge. Not every lawyer or advocate is well acquainted with the process, and it is more complicated. Even the senior most judges may not be may not be able to use these virtual courts so easily. He then writes, paralegal staff not well trained in keeping the electronic records. Yes, the staff which has been there in the courts for long durations, they have been used to the physical record keeping, but they are not trained for keeping the electronic records. That could also be another challenge. However, I feel that they can be trained. Of course, training will be a solution to this problem, because with the evolving technology, we have to adjust ourselves, we have to upgrade our skills. Coming to the next point, he is writing about the cyber security threats, risk of hacking of sensitive information. Okay, there is a huge risk because of cyber security threats. There will be a lot of sensitive information, especially whenever the government is a litigant or some major corporate companies are the litigants, and no litigant wants his information, his private information, to be accessed by somebody outside. Okay, so cyber security threat puts this risk of hacking of sensitive information. He then writes, litigants may not have trust in the process where they are physically absent. So there may be a trust deficit or lack of trust in the process when they are not physically present. They may feel that the proceedings are not happening properly. So these are the various challenges he mentioned for the creation of virtual courts. Let us see what he writes further. He is writing, COVID-19 pandemic has provided an opportunity for promotion of virtual courts by calling for physical distancing. The National E-Courts Mission Mode project, with a vision to enable ICT in all courts, has to be hastened, taking the advantage of the situation while at the same time enhancing the cyber security architecture and addressing the other concerns of e-courts. So this is the conclusion he is giving to the answer, where he is telling about the National E-Courts Mission Mode project, which has already been started by the government of India. We have to further it, taking the advantage of the situation. Okay. Also, he has told that these challenges which are existing have to be addressed while trying to further the idea of virtual judiciary. So I think this is a decent enough conclusion. If we analyze the entire answer, he has written a good introduction describing or defining what virtual judiciary is, and then he moved on towards the advantages of virtual judiciary. Okay, in the advantages he has written in great detail various advantages, but I felt he should have written something about the problems, especially those that have been asked in the question, that is the long pendency of cases as well as the improper utilization of resources. So he should have given some problem statement. He then wrote about the challenges of e-courts, which he covered in great detail, and he has written a good optimistic conclusion. Overall, it is a good answer except for that avoiding of problem statement, and he has written very few value addition points. Let us all come to the end of our discussion. Before ending, let me give you the task for today. Read about the various issues associated with the judiciary in India. Read about them, make a small note of around 150 to 250 words or 2 to 3 pages, so that it will be ready for your mains preparation. Okay, let us all meet again tomorrow. Thank you.